Millions of Americans own the rights to oil and gas underground. When they're approached by an energy company to lease out those rights, they're offered a cut of the revenue, called a royalty. Royalty income that mineral owners receive can depend in part on the state where they live. In North Dakota, estimates show that in recent years companies have been deducting hundreds of millions of dollars annually to help cover the costs incurred once oil and gas leave the ground on their way to being sold. North Dakota officials have not stepped in to help royalty owners, even though the state, in its own leases, has explicitly prohibited oil and gas companies from taking deductions from government royalty payments since 1979. In contrast to North Dakota, at least 7 oil and gas producing states have taken either legislative or judicial action to restrict the costs that can be deducted from royalty owners' checks. North Dakota Gov. Kelly Armstrong has called the oil and gas industry a key economic driver. The industry contributed significant tax revenue to state and local governments between 2008 and 2024. And more than 50% of all local tax collections are tied to oil and gas. Oil and gas companies owed the state's private mineral owners an estimated $4.6 billion in 2023. Before deductions. Deductions from that royalty income are deeply contentious. Companies say they're withholding transportation and other expenses that should be shared with royalty owners. The owners say those post-production deductions shouldn't be permitted in most circumstances. The energy industry explains that post-production deductions, which began surging about a decade ago, reflect changes in the oil business. Oil now requires more processing and transportation to sell it farther away, which companies claim benefits royalty owners. The increase is also attributed to regulations reducing natural gas flaring around the country. State Supreme Courts in Colorado, Oklahoma, Kansas and West Virginia have determined oil and gas companies are responsible for the costs that make the commodities marketable, limiting expenses passed to royalty owners. West Virginia provides royalty owners the most protection, barring deductions unless explicitly allowed in the lease. Courts ruled that ambiguous lease language favors the royalty owner. Rulings in states like Colorado, Kansas and Oklahoma vary but impose cost-sharing limits. Other states, including Texas, Louisiana and Mississippi, have court decisions friendly to the industry, allowing deductions unless leases prohibit them. Pennsylvania resolved a case where excessive deductions were alleged with a settlement. In North Dakota, the Supreme Court has sided with companies. It ruled that royalties should be based on the value of oil and gas when extracted, and post-sale costs can be shared proportionately with the royalty owner unless leases specify otherwise. North Dakota legislators have argued disputes should be settled in court. They rejected a 2021 bill to prevent deductions unless leases explicitly allow them and a 2023 bill requiring more royalty calculation transparency. Industry representatives warn that limiting deductions would drive away investment. Mineral owners contend lease negotiations are skewed against them, especially for older agreements, and call for legislative intervention.